here. Myself, Dr. Remya Krishnan R, faculty at the Department of Economics, NSS College, Pandalam. As we all know, today is the second day of our online faculty development program on Introduction to Indian Knowledge System, incorporating traditional knowledge and intellectual property rights, which is organized by Bharat, Vidya, Prayojana division of IGNCA, Ministry of Culture and Education, Government of India, in collaboration with NSS College, Pandalam, and Chinmaya Vishwavidyapeetham, Kerala. I'm entrusted with the duty to introduce our esteemed resource person for today's program, Advocate K. Gireesh Kumar sir, for taking the session on Essentials of Intellectual Property Rights, illustrated with case studies. Sir is an advocate with over 2 decades of rich experience in Mumbai High Court and the Honorable Supreme Court of India. Regarding his academic journey, Sir had completed his graduation in law from Government Law College, Ernakulam, and after that, he had enrolled himself as the first batch of students of LLM in the prestigious University of Mumbai, which introduced the post-graduation in intellectual property rights law for the first time in India. He has bagged another LLM in international arbitration law as well. He started his career as an advocate in Mumbai High Court, and continued there for nearly 6 years. Later, he shifted his practice to the Honorable Supreme Court of India since 2006. Having worked with many reputed international legal organizations, he had founded a legal firm of his own, having offices in New Delhi and Mumbai, specialized in white-collar crimes. He has successfully contested the cases of various corporate houses and public sector in India. So it's indeed our privilege to have such an eminent research person with specialized knowledge in IPR, arbitration, and constitutional law. On behalf of all the participants gathered here and on behalf of the organizers of this FDP, I extend a very hearty welcome to you, sir. Looking forward to your insightful session. Thank you.
Sir, please unmute yourself, sir.
Yeah, thank you. Thank you for reminding me for, Normally it happens, sir. Good evening to all. Actually, it's an honor to present a paper here. It's August, the audience, we can say it's all lectures. I come to know that's all our lectures from different colleges. And it's an endeavor by a Ministry of Culture, what I feel that by UGC, and to know, it's our, what we can say, it's we are bringing Indian knowledge and traditional knowledge to a new horizon. We are trying to make a new horizon. That's why it's my role to give some inputs regarding intellectual property rights, which I am feeling it may be the right topic. For I am very much delighted to say that I was the first LLM batch. I got an opportunity to be a first batch in LLM conducted by Mumbai University in IPR. So now it's after 24 years. It's going in 2000. It was in 2000. Now that time it was in a very infant stage. Nowadays, the role of the IPR is that much predominant today's world. So, I would like to bring you some inputs. So, I think my PowerPoint presentation is not working with the person who is coordinating, not giving some, not permission is giving. Would you please do some work for that?
Ranjit sir, please.
So can you please try to share that?
Yeah. I'm sharing, but unfortunately, it's not happening.
So please click on the share screen button and then
Yes, I'm doing.
you need to select that tab.
Yes, I am doing, but unfortunately, it's not happening.
Yes, sir. Now the screen is visible.
Yeah, screen is visible now.
Yes, sir.
Sorry, sir.
Yeah, I think now I got permission. I think so. Yes, today my topic is essentials of intellectual property rights. That's what I am going to say. See, what is at first I would like to
So you
I
haven't
would like
opened
to
the
enlighten
slide.
you. That's what is that? Yes,
Sir, kindly
Am I
open
audible?
the PowerPoint presentation.
yes, I opened the PowerPoint presentation. Now the slides are available.
Not, sir, not, sir. Just the content screen is visible now.
Okay, let me check. Now it's okay. It's getting.
No, sir.
Not, sir, not, sir.
Yes,
I
sir.
think
Kindly
Okay.
double click again.
Can you click on that again?
yeah.
PowerPoint presentation. Okay.
Yes, I am doing. It's here, unfortunately, but it's not showing. Um, one second, let me check.
Yes, sir. It's visible now.
It's okay.
Yes, sir.
Okay,
Sir, make
yeah,
it full screen mode.
yeah, of course. Some the technical glitches are here. Very unfortunately, I'm sorry for that same. Yes, it's am I audible?
Yes, sir. Please, please.
Yes. It's yes, okay. Then first we want to know what is IPR. That's a normal word you may hear several times, but what is IPR? IPR is a vast area which you would like to know. IPR can be defined in such a way that intellectual property rights are the rights given to a persons over the creations of their minds. That is IPR, intellectual property rights. They usually give the creator an exclusive right over the use of her creation for a certain period of time. So normally there are a lot of laws regarding IPR. There are a lot of bunch of laws, a bouquet of laws are coming under the IPR. That is, one is the most important is Patent Act 1970 and Rules 2003. And second one is the Designs Act 2000, Rules 2021. After 20 years, the rules were formulated. And there is a Copyright Act in 1957, Rules 2013. And there is the Trademark Act, trademark of any product. That's 1999, Rules 2017. Then Geographical Indications Act 1999. So, what the geographical indications means, you may hear about like Assam tea or Darjeeling coffee, something like that. The Geographical Index Rules 2002. The semiconductor integrated, that's a kind of a new law which was added in 2000. A semiconductor integrated circuit layout designs act 2000 and 2001. And trade secrets, there is a trade secret that is, we can say,
Excuse me, sir.
yes,
Sir, can you go to the second slide? It still
yes,
shows the first. Oh, yeah, right.
yeah,
Okay,
yeah,
sir.
yeah.
Thank you.
Trade secrets, common, that is governed by, there's no law regarding trade secrets. That is governed by common law. That is any laws of India, intellectual, that is IPC, that means Indian Penal Code and other contracts acts. So now, what are the essential elements of intellectual property? That's a very important aspect. That's what are the essential elements of intellectual property. The intellectual property rights include trade secrets, utility models, patents, which I already mentioned all these things. These are the rules that we can say, okay, act regarding patents called Patents Act, act regarding trademark called Trademarks Act. Likewise, geographical indications, industrial designs, layout designs of integrated circuits, copyright, and so and so, so and so, so and so. This which already we mentioned. So, what is the importance of IPR? That's what is the importance of a legal right under the IPR. So IPR, that means intellectual property rights, thereby gives a legal right. Very important aspect is that the person who owns a IPR, intellectual property right, it's a legal right. That is the most important word. It's a legal right over creation of the mind, including both artistic, that means it can be an artistic or a commercial creations. Any kind of creations can be either it may be an artistic or it's a commercial creations. Intellectual property law provides owners. It gives us such a kind of right to the owners of the intellectual property rights with a certain exclusive rights. That is the most important thing, is that exclusive right to a variety of intangible assets. Intangible, not it cannot be touched. That is called the intangible assets, as well as the financial incentive of monopoly profits. So those who are getting the intellectual property right, for example, it's a trademark, or like for example, it's a McDonald's, it's a any otherwise KFC. These are the trademarks. A lot of trademarks are there. So who are getting this? If any kind of infringement of such kind of a trademark, if one person gets a patent of such any product, if somebody is steal it, so there is a legal right. He can sue before the courts and he can get the whatever the damages from the honorable courts. Likewise, any kind of a copyright violations, any artistic work, he can go to the court. And likewise, the trademark, geographical indication, like no person from Hungary cannot make a tea in the name of Coorg tea or a Darjeeling tea or such kind. there are geographical indications regarding some that is governed by Geographical Indications Act. So, in the general principle, we can say the IP law is the creator of intellectual property is considered to be the owner of it. So, who is the person who creates? The creator gets the ownership, the license. It's cannot be tamed as a license. It's kind of a ownership that is called a IPR or intellectual property right. So the effect of this principle can be significant unless the commissioner and the creator of work of invention agreed otherwise in writing. So any person who gets this right, he can transfer this right to any person by entering any kind of a contract, any private contract, whatever may be. He can give it as a license to any other person also to use the same. So this can be normally we can say these are the normal caricature of IPR. Now, why IPR is important? That is the main question we have to ask ourselves. Why it is why we are going to take a license? Why we are going to register it? These are the very important aspects of IPR. The primary function of intellectual property rights is to protect and stimulate the development and distribution of new products. So it is given a kind of a right to a person who owns this IPR, who owns the intellectual property right, who owns the license, who owns the who is the creator. He has such kind of ownership. Nobody can steal it, nobody can distribute it, nobody can make any kind of development by infringing his rights. That is, any creature cannot exploit the inventions, trademarks, designs, creative content, or any other intangible assets. So it can be a inventions, literary or artistic work, which I already told, and that's like a symbols. It can be a symbols, images, names, any names. No, we can't uh, copy the names, designs used in commerce and in original expression of creative individuals. So these are the very important points regarding IPR. In this aspect, India have formulated a national IPR policy in 2016. Encompasses all IPR into
Sir,
a
excuse me, sir.
single. Yes.
Sir, the slideshow is not working. Can you
Okay.
click on that slideshow?
Yeah. I am just explaining the first slide only.
Okay, sir.
That's
Okay.
yeah.
Thank you.
That's the general idea of IPR. Then I will go to our topic. Actually, our topic is traditional knowledge, likewise Indian knowledge and such sorts of things. I will come that apart secondly. First, we want to get an idea of what is IPR and other things. So these are the area which I already told you: patents, trademarks, industrial designs, copyrights. These are the eight diversifications are there. Eight types are there. These are normally we call it as a IPR, intellectual property rights. So any kind of that, for example, now we can go to how IPR is protecting our traditional knowledge and how it's relevant nowadays to give a protection to our traditional knowledge. That is very important aspect, which I can say. Traditional, what is traditional knowledge? That's the most important thing. What is traditional knowledge? I think yesterday there might be some reference regarding traditional knowledge. A traditional knowledge is a cumulative body of knowledge and beliefs handed down through generation by cultural transmission. For example, any tribe, there are a lot of indigenous tribes are there in India, everywhere, in Africa, Australia, any country, the lot of
Excuse me, sir.
yes.
Sir, sorry to disturb you, but still we are on the second slide only. That what is IPR?
Oh,
Hello.
Sir, kindly continue.
Yes,
Been talking, sir.
am I audible?
Yes, sir.
Lot of issues are here. I don't know what's happened today.
अच्छा अच्छा PowerPoint ऑफर की
Anand sir. Hello, Anand sir. Hello. Anand ji.
Yes, Sanjay sir.
Yes, ma'am. Shall we continue without PPT, ma'am?
Sir, it's something.
Kindly, let us proceed without PPT.
Yeah, sir.
Sir, ask him to share the PPT with you, and
Yeah.
you can play the PPT as and when he asks you to change the slide.
Yes, yes.
It's okay now?
Now it is visible, sir.
Yes, yes. Thank you. But now visible. Okay.
Okay, sir.
So please go to that slideshow button.
Yeah. That's I already doing the same, but I'm very unfortunate. Not. Yes. You can see that?
Yes, sir. But
So now
still,
it is
Hello?
moving, but still not in the slideshow.
slideshow mode, right? Now it's the second slide.
Yeah, now it's the third slide. Now it's okay.
Yeah, the third is visible.
Okay,
So
okay,
it will be better if you can go with the slideshow. Yeah, that's the one. Yeah,
yes, thank you. Yeah,
please click
sorry
on that.
for. Yeah. Sorry, I'm very much sorry for this. Yeah. So now we are talking about the traditional indigenous knowledge of India. We have a lot of tribes, especially in India, all over the world. They have their own knowledges, indigenous knowledges, and that's why when I was talking about the Assam tea, Darjeeling coffee, so and so, geographical indications, and lot of things. Now, the traditional knowledge. Now we can go about what is traditional knowledge. So traditional knowledge is a cumulative body of knowledge and beliefs handed down through generation. I already told you, handed down through generation by cultural transmissions. So it is not, so we cannot say that it's from a very recent. No, it is from from our heritage. What we can say from they are transferring from generation to generation, generation to generation. This kind of knowledge is there. So the what we can see that nowadays this kind of knowledge is are stealing by big corporates. That's a very pathetic situation, and it's a we can say it's a present as per the WIPO and WHO. This kind of stealing of traditional knowledge and making medicines, it's $100 billion business. So it's not a small amount of money it's pouring on here. So this kind of knowledge sharing without getting any consent from this kind of indigenous people, the big corporates, so who is a person who is more clever, they are taking advantages of innocent tribes and their traditional knowledges. So this is what happening everywhere. Now that's for that thing we need to protect all this kind of exploitation of this traditional knowledge. That is what the government is also doing. The World Health Organization, WIPO, World Intellectual Property Organizations, and United Nations are intervening in this kind of problems, and they are taking adequate steps to protect this kind of indigenous knowledges, especially in the field of pharmaceutical, that's in the field of medicines. So what we can say, the traditional knowledge is that much pivotal knowledge regarding regarding the respect of indigenous people, so tribal people. So traditional knowledge is an important element of the intellectual and cultural heritage of indigenous people. So it reflects their social and historical identity, significantly contributes to the future well-being and sustainable development. So it is. I already told you that it's a transferring from one generation to other is going on and on. So that's why every in India, for example, I can say that in Aramula mirror, that is a traditional knowledge. Likewise, there is a tribe in Wayanad or something like the Wayanad or Palakkad, something Kani tribe. They have developed they know some kind of a knowledge regarding in Malayalam it says Arogya Pacha, something like Jeevani. This was exploited. Their traditional knowledge was exploited by some pharmaceutical firm, some Ayurveda firm, and they got the patent regarding that, and they developed a kind of a medicine and they distributed. They amassed a lot of wealth. Later, by the intervention of Kerala Shastra Sahitya Parishad, that's an NGO, it was protected. And Shastra Sahitya Parishad is doing a tremendous work in Kerala. Likewise, a lot of other agents, NGOs are in India to protect the traditional knowledge of preserving their this kind of indigenous peoples a kind of traditional peculiar knowledge from the exploitation of by this kind of big corporates and this thing. So this protection of traditional knowledge, that's in a worldwide is happening. That's what I told you. It's a matter of $100 billion at present. This thing. In 2003, there is a protocol of there is a Cartagena Protocol on biodiversity regarding this kind of to protect this biodiversity and this kind of knowledge. In Article 8 of CBD, that's a Convention on Biodiversity has been happened in 2003. Then there is a specific article regarding protection of traditional knowledge that was drafted on those time by around 196 countries were agreed for the same. The similar way in 2014 also there is another protocol implemented that is called a Nagoya Protocol. These are the protocols by the United Nations regarding to protect the traditional knowledge sideways. The similar way there is a in 1995 the agreement relating to the trade related aspects of IPR in 1995. That's called a TRIPS agreement in 1995. And you know that in 1991, there is a world, India entered a signed a GATT agreement, and also we entered a WTO agreement. This kind of World Trade Organization came into the picture. The markets were open. Lot of big companies are going there and here. Lot of issues relating to the trademarks and the trade with commercial exploitations happened. So to protect all these things, there was an agreement that is also by the intervention of United Nations agreement on trade related aspects of IPR in 1995. It was drafted. So the same way in 2007 there is to protect the right of indigenous people. The United Nations declarations of protect the right of indigenous people. So the similar way, India also followed one policy called a National IPR policy in 2016. India followed the same, and India is being the one of the members of the United Nations. India is following this kind of for protecting the IP, the indigenous people's knowledge regarding this medicinal and other craft, textiles. You know that Benares saris, Kanjipuram saris, these all are traditional knowledge. They have their own treasure of knowledge regarding their craftsmanship and everything. So this kind of knowledge is normally we can say they are exploiting by other persons, and they are getting patent, they are getting copyright, they are getting trademark, and they are selling like an commercially exploitation. So nowadays the question arises nowadays why we are going and why the Indian knowledge, why our traditional knowledge we have to preserve. So traditional knowledge, we have to preserve traditional knowledge. Lot of questions by this. Maybe you may. I think some may ask why we are good, want to learn about traditional knowledge and other things. Why we want to protect our traditional knowledge and other things. Yes, it is the right of every citizen of India to protect the traditional knowledge. For example, in Kenya, one Jiva, then one product is that was duplicated in Taiwan. This is internationally. This is happening. So it is not a matter of India. Everywhere it's happening like everything. So it is the duty of every citizen to protect the IPR, to protect the traditional knowledge through the way of through the legally way. That is the importance of IPR. For that, what you can say. So another way is what we can say that a lot of biopiracy is happening. You know, biopiracy means what we can say. Biopiracy is any kind of a stealing of any uh, it can say it can defined as a stealing of biomedical knowledge from traditional and indigenous communities or individuals. That we were discussing about what biopiracy. The terminology is stealing of this kind of indigenous knowledge is called biopiracy. The term can also be used to suggest a breach of contractual agreement. Any kind of a contractual agreement that also we can term it as a biopiracy. In a simplest way, we can say stealing of one's traditional knowledge is can be it's a biopiracy. So we have a lot of cases regarding the same in regarding biopiracy. You are well aware of the case of turmeric, the case of neem, the case of basmati rice. Lot of cases are there regarding this turmeric and everything.
Sir, please change the slide.
Yeah, I'm going to now you are seeing biopiracy.
Sir, if you
Hello?
can end the slideshow, because you are not, if you end the
Still it
slideshow,
is
then
in
it will be visible.
Yeah, biopiracy is business. I'm explaining regarding the case laws regarding this turmeric. Now we can talk about the term how turmeric was patented by an American company. That's a very interesting aspect. Turmeric was patented by American company. That's a U.S. patent was granted to the University of Mississippi Medical Center in 1995. So turmeric was patented by American University, that's called Mississippi University in 1995 for the use of turmeric in healing wounds. The patent also granted from the exclusive right. So that is the very threatened, alarming situation here. Once patent is given to us, one company or whoever may be, then they will get an exclusive right to use, to sell, to whatever they can do it, the commercialization. So this made it shook the world, especially in India, how turmeric can be patented from an American company called Mississippi University. So this was challenged in USPO, that is United States Patent Office, by CSIR, our Council of Scientific Research Institute of Research was patented. They challenged this patent of turmeric, and we succeeded that. But the problem, for this kind of challenging of turmeric, it cost millions of legal fees for the same. That is another problem. The same way, neem, neem is very rare here. That was also patented by another company. They got a patent in America as well as in European Union Patent Office. They got it. Then it was challenged again by India. It is in our Ashtanga Hridaya. It was saying we have a lot of Sanskrit shlokas regarding the same, and this is our traditional knowledge, and these are the things we are using for the from generation to generation. Lot of dimensions we will take, lot of difference we will take in this kind of things. Then European Union was European Patent Office was given a kind of withdrawn that patent, but American US Patent Office was given a slight direction. They modified their order, but it was given a complete withdrawal. It won't given a complete withdrawal by the US Patent Office. The similar way in basmati rice, the similar way amla, gooseberry, the similar way karela, brinjal, lot of things was patented by lot of in our own tradition that was patented by different multinational companies, and they were using a lot of these things. And what happens Here, the importance, the role of IPR, they came into the picture and they were patent. We got back this patent and we tried our level best to we have to get back our whole dignity and everything. So this is what that was the role of this IPR and everything. So for that purpose, what India has done now, the Indian government has done a lot of things like the traditional knowledge digital library. India made a traditional knowledge digital library. So every kind of knowledge was documented in a word format and in different languages. And whenever these people get, we can't claim, we can't complain to the US patent office, or we can complain to the European Union or whatever the patent office or Australian patent office, only because of when they go into when one person coming and to get a patent, they can't getting any access to whether any person is using this exclusive right. No database is there. Now, for that purpose, Indian government has given started a step to make a database for all these things, and they used a technical that's a traditional knowledge database library. So when hello. So this traditional knowledge digital library, it is protecting when anybody goes in the name of aloe vera or whatever may be the medicines or any of these things, that they can directly come to the knowledge of this. This was already in the library of India, traditional knowledge digital library. So they won't give any patent to this kind of any kind of a new patent. They won't venture to give any patents. So this is what happening worldwide nowadays. So that is the use. That is the endeavor by the government where they were from time to time they done a very good job regarding by understanding and the predominance of this IPR and IPR related laws. So this kind of uh, these are very helpful nowadays. Uh, what we can say, and nowadays the latest some other international agencies like WIPO. That WIPO means World Intellectual Property Organization. Uh, this is the global forum for intellectual property policy, services, information, and cooperations. They are coordinating India things all over the world. Actually, a long-standing debate over that interplay between intellectual property and public health. See, in respect of public health, there is a question will rise. Is a life-saving medicines how the patent can be used? This kind of questions was raised in international level, especially innovations and access to medicines intensified to the run up to, for example, World Trade Organization Doha Ministerial Conference in 2001. World Trade Organizations came into the picture, and Doha Ministerial Conference in 2001, they discussed about the HIV/AIDS, the medicines of HIV/AIDS, whether anybody can exclusively use this HIV/AIDS medicines or anything. Then there is another agency called Doha Declaration on the TRIPS Agreement and Public Health. That is known as Doha Declaration on the TRIPS Agreement and Public Health. Addressed the critical concerns about the role of TRIPS. TRIPS means trade-related aspects of intellectual property rights in relation to medicines and clarified core principles noting the significance of IP for the innovation of new medicine, but also concerns about its effect on prices. So this is the another area which came into the picture of IPR. How the medicinal rights and everything can be protected by this kind of international agencies like WIPO and WTO. So this was again in 2020. We know that 20 COVID pandemic was there. Then there was a declaration again in by the WTO regarding these things. Exchange the knowledge. That has also happened. This IPR is giving a lenient view in respect of life-saving medicines. So these are the things which is happening globally regarding the regarding in respect of protecting the life-saving medicines, even though they have an exclusive right over the they have exclusive patent right over the medicines or the inventions, whatever may be. This is happening. This has happened in June 2022 by WTO Ministerial Conference in Doha. So now we can come back to the Convention of Biodiversity. That is another aspect by the National International Forum, by the Convention of Biodiversity for Safety and Convention of Diversity for protecting the indigenous knowledge and its protections. So now what we can do, this kind of things regarding protection of convention of biodiversity. So that is also very important. We have to think about how we can do all these things. Now, there is a lot of what first we want to do. There is a documentation of a traditional knowledge. That is a very important aspects what we have to do regarding the document of traditional knowledge. It is one means of giving recognition to knowledge holders. But mere documentation may not enable sharing of benefits arising out of the use of such knowledge unless it's backed by some mechanism of protecting the knowledge. So these are the way first we can how we can protect the traditional knowledge. Second way is that the second method is that the registration of this kind of knowledges. That's but the how registration helps. Registration helps is the creating a system of registration. That's why now we discussed about the traditional knowledge digital library system for registration of innovations by the inventor or traditional knowledge holders. These are the things also which we can do. The same way, developing contracts. When one person having a right, when one person having a knowledge or a group of people having a knowledge or something like that, they can enter into a contract with other persons. For example, a tribe knows a knowledge and it is a very life-saving medicine or whatever maybe it might be an artistic work or whatever maybe things. Those people or who are the tribe, whatever may be, they can enter into a contract with other persons or any big companies. They can they can get a commercial benefit also from this kind of entering a developing contracts. The third one is within we know grant of IPR. So that is if it is a trademark, we have to go buy a trademark card. If it is a copyright regarding novel or any artistic work, we can buy copyright tag. Any geographical indications is there, then we can go to that way. We can get the registration or license under that aspect. These all things we can do it. So another method is what we can call it's development of sui generis system. This is sui generis means the indigenous method of a protecting law. That is called sui generis system. The same as it's the same kind of things, the peculiar things that we can do. We can protect it by the IPR by going to the right forum and everything. So that is another way we can protect our tradition knowledge through the medium of IPR. These are the ways which we can talk about. Now, sui generis is the system which we are following in a similar way. This will be discussed by, I think, tomorrow, the section regarding traditional knowledge and defensive system and a positive system. Positive. Although this will tomorrow's subject, I think tomorrow's subject is regarding the same only. That's why I'm not going to into depth such a way. So, in a nutshell, I am giving only a introduction of this IPR and everything. The time made very constrained. I know that, but this IP in a nutshell, we can conclude this way that IPR is protecting, trying to protect our traditional knowledge. And you know that India is a country very having a vast tradition and knowledge and everything. So it is a very right. What we can say? It is a right of everybody. It is a right of every citizen to protect that cherished knowledge. That's why we can. That's why we are fighting before the USPO, before the Australian patent office, before Japanese patent office, before the European patent office, and we have already done a tremendous work. The similar way, especially a lot of NGOs are also doing the similar way, like Kerala Shastra Sahitya Parishad in Kerala. Lot they are doing a tremendous work regarding the protection of indigenous knowledges, especially from the tribal community. So these are the things. This is a way IPR helping to protect our rich old heritage and culture. In the same way, rich old our tradition knowledge and everything. The government and or maybe every citizen, not a government, can fight for these things, and it is our duty, it is our time to get to know all these kind of things. I think I am concluding. Thank you so much.
Anandji?
Thank you very much, sir. And now the floor is open for discussion. Participants, if you have got any questions, you may please ask. Thank you.
Please, sir, kindly close the share screen.
Yeah.
Good evening, Professor.
Good afternoon.
Professor, am I audible?
Yes, yes, you are audible.
Professor, this intellectual property rights, when they get a
Yes.
patent, in somewhere, if the idea is published as a book, will they check that is already that's a idea which is published in the book, and if that case, a patent would be given for that idea, Professor?
That's what I told you about the India has done a tremendous work. Indian government, not now, it is in very way back. Um, we have a digital library regarding our traditional knowledge. So once we have a traditional knowledge, the how the patent office works, I say that how the when one person goes to any patent office to get a patent, they might have given a specification regarding the same, and the patent given to only a novel, very innovative and novel. That's very important word is novel. Now, novel means it should be the first of its kind. So, if something is even some countries using something like that, or any other tribes using indigenous people is using that something like that, it may not get any kind of patent. That is why, in respect of turmeric, neem, and a lot of things were patented at first. Why? Because the US Patent Office given the patent only because of they don't know that it was used by the tribes, or it was used by the people in India or something like that. It was in the Ashtanga Hridaya. Then we have done our objection before the US Patent Office, before the European Patent Office. We have quoted all these things and we have to brought all these things. Your question is, if it is mentioned somewhere, patent is not given to anybody. But we have to prove there is a lot of mechanism, that is a legal mechanism. In a simplest way, I can say, if it is somewhere it is mentioned, it is not given. Thank you. Next.
Thank you, Professor.
Excuse me, sir.
Yes.
Good evening. This is Dr. Shilpa Vinsurkar from GHRC Nagpur.
Yes.
Sir, it was very excellent presentation and information from your side.
Thank you.
But I have one question on geographical indications.
Yeah. Yes.
So, for example, just Nagpuri oranges.
Yeah. Absolutely.
So,
Yes.
So if suppose somebody has took a crop of oranges in his farm and those oranges are very sweet, so can that person give his name after that oranges? Like, for example, my name is Shilpa. So Shilpa oranges, can I do that?
That's a yes. That's a very very good question. The Nagpur oranges, nobody can use it. Nagpur, because that terminology relating to any place, Nagpur oranges, like Dehradun. So, see, I can use one name. That is, they can give some name like any name. For example, Shilpa oranges. Shilpa orange. I can say Shilpa Nagpur oranges. That name they
Okay.
can say, but they can't say it's a pure Nagpur oranges. We can use the terminology, the Nagpur oranges for everybody. Nobody can claim exclusive right on geographical indication. There is a lot of case
All right.
laws by
All
the
right.
Supreme Court as well as High Court. Yes.
And if suppose it is done, then in that case, NMC will claim this. No, ki why you should have put your name against that oranges.
Yeah, absolutely. That's we have there is a clear-cut law regarding the same geographical indications rule, act and rules we have. So that's the patent IPR. It comes under the IPR, geographical indication. Very important point. Lot of geographical indication. Benares sarees, Kanjipuram sarees, lot of
Yeah,
things
yeah.
are there.
Okay, okay. Thank you so much, sir.
Okay, yeah.
Namaskar. Myself,
Yes.
Devi Prasad Misra. Can I ask a question?
Oh, of course you can ask.
Okay. Thank you very much for your wonderful presentation on IPR issues related to IKS. And I'm having a couple of things. One is that I'm curious to know about, if you look at the biodiversity product particularly,
Yeah.
lot of things, how to protect that, because a lot of things people are taking and tweaking it, and then particularly Western countries, and
Yeah.
also some of the Indian farms. That is the one concern, how it is to be protected.
See,
Because India
there is a
yes,
protocol regarding the same. There's two protocols. One is Cartagena Protocol in 2001, and there is another protocol is called Yokohama Protocol. These two protocols by CBD, Central Convention of Biodiversity, that is by the United Nations. The 196 countries is the member of this Center for Biodiversity. So, if any person or anybody is using any kind of this kind of lot of flora and fauna in everywhere, the separate flora and fauna is there. every tribe or some particular regions have their own way of agriculture, their own way of seeds, and then that's why with the case of cummins, jeera kind of things. That's a case because particular seeds or particular plants, everything cannot be copied. There is a basmati rice case also. Basmati rice case that is also patented by the American company. One America, US patent office got a patent given to basmati rice. Basmati is from a Punjab. So these are protecting nowadays. Yes, a lot of malpractice is happening. That's why I told you. Even though today also a lot of things were steal. That is called biopiracy. Biopiracy is
Yes.
happening. We have an
Actually, I
adequate
was
platform.
talking about biopiracy. It's good you told me. But see, at least I know a couple of people, particularly Western people, and along with the Indians, they are going to the deep jungles and taking the thing and then changing it and then giving a product, okay, to the our country and other countries. Now, unless otherwise there is a concerted effort by the government, by the public and other things, because no foreigner can really enter into jungles without the help of our people.
Correct.
Okay.
Yes.
Right. It is, at least I know a couple of them. That is a great concern. But actually, how to go about it?
See, for the specific things, we have a specific law that is called Plant Varieties and Farmers' Rights Act. Plant Varieties and Farmers' Rights Act. The protection of seeds, plants, we have act. But you know that in India, even though whatever the acts, whatever the rights we have, is
Yes.
happening. Stealing is happening everywhere.
Yes.
So if we can find out, we can challenge it. Now we have a concrete law regarding the same. That only we can do through IPR.
Okay, but thing is that like people are not concerned. I'm like,
Yes, that's a very
see, and also
shameful about regarding the same.
okay.
People are not concerned, and people are selling for some pennies. They don't know what is
Yes,
the value of
I
that.
will give an example. Like, let's say the organic farming.
Yeah.
See, basically, at least somebody was telling me, and somebody like it was taken basically from India, which was a natural farming. Okay.
Yes.
In the Green Revolution during that time, some people introduced the Green Revolution. Some people came and learned the also natural farming. And today, the organic products are much costlier than the chemical farming, which was not a part of our country. Natural farming was a part of our country. Now, if you look at it, it's already killing, taking a toll on that.
That is called a traditional knowledge. That is called traditional knowledge.
Yes.
Traditional. Every country, every tribe, every community has traditional knowledge. This is called res commune. It is relating to a community, not a person. This what you rightly told about this organic farming. It's we are transferred from generation to generations. We cannot say who is the inventor of these things. It's res commune. It's owned by a particular community and going on and on.
No,
Now,
actually,
you being a citizen
organic
of India, it
farming,
is your right to protect it.
organic farming has basically come from the Western country. Okay, to my knowledge, and the natural farming was a part of our, part of our country. Okay, maybe different district, different state will be having different way, but it was almost similar, if not same.
Yes, the very secondly, organic farming and natural farming, whatever may be the world is very vast. How it can be implemented? The question of implementation is very difficult. Yes.
So may I ask one question?
Yes.
Sir, what steps should a company take to protect its intellectual property from infringement in global market?
Global?
Market.
So that is that's we have a, I already told you, TRIPS. There is an agreement by WTO, World Trade Organization, and trade-related aspects of intellectual property rights, that is called TRIPS agreement. This is that is controlled by the United Nations, because this WTO and WIPO, World Intellectual Property Organization, these are the one of the organs of United Nations. Now, to protect the infringement of this kind of global whatever things, it can be taken by only the United Nations. There is no law for the same. This is it's an international law. It's concern of international law. So the intervention of United Nations only can be protected this kind of exploitation. But that is another aspect I can say. The social science is completely different. It's a capitalism and whatever these things that is happening everywhere. So there is no law for capitalism to prevent. We have a law for preventing exploitation, like a competition law and so on, so things. That is completely different from the perspective of IPR. Competition law is there. There is a company law, locally company law is there. There are contract act is there. These are the things that's a common laws. That's why trade secrets comes under the common law. There is no specific law for that. For example, trade secrets called as some KFC have a trade secret. Coca-Cola have a trade secrets. These are comes under the different field of law.
Sir, thank you.
You're welcome.
I think there are no questions, so we can proceed for concluding.
I request Dr. Jayalakshmi to please deliver the vote of thanks.
Teacher, am I audible?
Yes, yes.
Yeah, yes.
Good evening, all. It's a great privilege given to me to propose vote of thanks for today's session. Today, we got an eminent resource person, Advocate K. Gireesh Kumar, and hope that all have enjoyed the session of IPR. I am sure that we carry forward the information which was shared by the resource person. At first, I express my heartfelt gratitude to the principal of our college, Professor Dr. M.G. Sanal Kumar. On behalf of NSS College, Pandalam and HRDC, I express my gratitude to our resource person, Advocate K. Gireesh Kumar. And I also propose vote of thanks to the organizers of this FDP and all the participants who were presented here. Thank you all.